let us examine each and every segment of this lecture, which centers around doctrines and principles for extraterritorial application of competition law in European Union. So first and the foremost, we will talk about again the doctrine of extraterritorial application of competition law in European Union. Thus, dear learner, what we find that the competition law and extraterritoriality under the European Union and United Kingdom overwhelmingly prevalent under Article 81 and 82 of the Treaty of Rome 1985. Secondly, Chapter 1st and Chapter 2nd of the United Kingdom Competition Act 1998, and lastly, Article 101 to 109 of the Treaty on the Functioning of European Union 2009. These three legislation represents the panorama of extraterritorial application of competition law in European Union. And a careful perusal of these three enactments right from 1985 to 2009 leads to the fact that the long jurisdictional arm of Article 81 and 82 applied in matters of extraterritorial applications of competition law on the basis of three major doctrines and legal theories or legal construct. The one is the single economic entity doctrine, implementation doctrine, and effect doctrine through the series of judicial decisions of the European Court of Justice. And again, we will try to reiterate so that you can remember these leading cases when you are called upon to understand and explicate the ambit and scope of extraterritorial application. Then these cases happens to be A. Alstrom, Osa-Kehetio versus Commission of European Communities, and the case is popularly known as wood pulp case. The second important decision, which is a landmark decision, is called upon is the Intel Corporation versus Advanced Micro Devices Incorporation, which were decided after 11 years of the wood pulp case, meaning thereby in 2004. The third case happens to be the Innolux Corporation versus Commission Court of Justice of the European Union, which were decided in 2015, again after the 11 years of the decisions of the Intel Corporation. These three cases are to be taken as a test case to determine the scope, ambit, and purview of the extraterritorial application, along with the three laws which we refer to Article 81 and 82 of the Treaty of Rome 1985, Chapter 1st and 2nd of the United Kingdom Competition Act 1998, and Article 101 to Article 109 of the Treaty on the Functioning of the European Union 2009, to have a very broad and a holistic picture of the applications along with the intricacies and the delicacies involved in the principles of nationality and territoriality in application of extraterritorial jurisdiction of competition law in reference to the entity, single economic entity doctrine, implementation doctrine, and the effect doctrine. It has been well settled that the study of economic entity doctrine and implementation doctrine is recognized categorically or express verbis by the European Court of Justice. However, the recognition of the effect doctrine, which has been prevalent in the United States antitrust law, invariably under the extraterritorial application of competition law in European Union remains somewhat in reticence, somewhat it remains obscure. However, time to time, many judicial decisions and argument by the advocate generals manifested alongside the application of the effect doctrine, even in the European Court of Justice, in numerous cases, the effect doctrine happens to be visible in overt or covert forms. Having said so, dear learner, we will refer to economic entity doctrine, which was debated, articulated, and discussed in a notable case known as Diastuff's case. The Having said so, now, dear learner, we will be referring to economic entity doctrine, which has been debated, marshaled, and articulated in Diastuff case, and the full citation of this case happens to be European Court of Justice case number 48/69, Imperial Chemical Limited versus European Commission, decided in the year of 1972. This case is of seminal importance in representing European Community and European Commission's stand on the application of the economic entity doctrine. On the basis of the nationality principle, the jurisdiction was asserted over non-EC parent undertaking by attributing liability to them for illegal price fixing of the dyestuff by their subsidiaries located in European Community over which the non-EC parent undertaking exercised the control. So the ruling of the case well reflect that in Dyestuff case in 1972, the economic entity doctrine or single economic entity doctrine, sometime it is also known as single economic unit doctrine or single economic entity doctrine, was applied and the ratio and the ruling of this case having a far-reaching repercussions in construing the entire scope and purview of extraterritorial application of the competition law. For the sake of reiterating, what principle has been applied is the nationality principle, but jurisdiction was asserted over non-EC parent undertaking simply by attributing the liability to them for illegal price fixing and cartelization by the Diastuf company and their subsidiaries located in European community over which the non-economic community parents undertaking have exercised their control. The European Court of Justice decision in this case held that a subsidiary has a separate legal personality and it is sufficient to exclude the possibility of imputing its conduct to the parent company. However, the European Court of Justice in this case further goes on to record that by holding that such may be the case in particular where the subsidiary, although having separate legal personality, does not decide independently. I am just repeating the observation of the European Court of Justice that holding that such may be the case in particular where subsidiary, although having separate legal personality, does not decide independently. It regulates its own conduct on the market but carries out all material respects the instruction given to it by the parent company, and on the basis of their command and control approach of the parent company, the reasoning developed in the European Court of Justice was upheld and applied the single economic entity doctrine in this case. A similar reasoning or falling in line with Diastuf's case decision of 1972, the European Court of Justice had an occasion to delineate very clearly in Continental Can judgment. The full citation, dear learner and viewers, happens to be Europe Ballage Corporation and Continental Can Company Incorporation Commission in 1973, meaning thereby the decision of the Imperial Chemical Industries Limited versus Commission pertains to 1972, whereas in the quick succession to this case, in the next year in 1973, the European Commission buttressed the doctrine of economic entity or single economic entity doctrine in matters of extraterritorial application of competition law in European Union. How it developed this kind of a reasoning, that deserves a kind of a survey and kind of an inquiry. It is said that wherein the effect of the relevant practices alluded a response on the application of the effect doctrine was shied away from, but preference being accorded to handing down a judgment based on established doctrine of single economic entity. Thus, dear learner, we see that single economic entity doctrine has been recognized in 1972 and 1973 respectively in case of Diastuf's case or Imperial Chemical Industries Limited versus Commission's case, as well as Yoram Belage Corporation and Continental Can Company Incorporation versus Commission in 1973. Now, dear learner, we will be switching over to that how we see the actual implementation and application of the next doctrine, which is known as implementation doctrine. It appears to be alliterative somewhat to say application and enforcement of implementation doctrine as the name itself suggests. that the implementation doctrine, in a vast majority of cases, however, the fact remains the effect doctrine was not formally recognized by the European Court of Justice. As an alternate, the European Court of Justice has developed a concurrent jurisprudence through the instrumentality of the implementation doctrine, which have bearing on the ability to assert jurisdiction extraterritorially. Thus, we find its vociferous mention in the Intel case, wherein on the strength and the mandate of Article 102 of the TEFU 2009, the European Court of Justice found that the anti-competitive behavior of the Intel Corporation or Intel Company or the Intel case consisted of two different sets of abusive practices. One happens to be the loyalty rebates, and another happens to be the compensation payment of Intel. The European Court's finding in Intel's case is of far-reaching consequence in construing the actual application of implementation doctrine, because both practices, which in the eyes of the court found to be anti-competitive, includes loyalty rebates and as well as the compensation payment to its customer for their breaching the contract which has been concluded with its competitor. Thus, on a deeper sense or on the analogical deduction, what we find that there is not only the breaching of contract concluded with its competitor, but on the market side we find the CPUs, namely AMD, and the roots of the doctrine of the effect in the context of US antitrust law, which looms large on that case, but the European Court of Justice, by way of its convenience and expediencies, recognized only to the application of the implementation doctrine. In the case of Intel, applying the mandate of Article 102 of TEFU 2009. Thus, we see that the concept was developed within the European Union in order to establish the European Union's jurisdiction for the application of the competition law and provisions in cases of extraterritorial nature in Intel's famous case. Now, here it becomes pertinent, dear learner, to understand the major findings and outcomes of the Intel judgment, which has been handed down by the European Court of Justice in detail. A perusal of the ratio and the ruling of the Intel judgment as regards to the jurisdiction, we find that the European Court of Justice basically followed the General Court's first instance decision. It recognized both the implementation doctrine and as well as, it's very interesting, dear viewers and learner, to see that how in the name of application of implementation doctrine, the European Court of Justice is going to have a savory or unsavory mixture of the effect doctrine of the United States. So what we find that it recognized both the implementation doctrine as well as the qualified effect test as stand alone and the independent means to establish jurisdiction for the application of the competition provision in the Intel case. The court observed, and I quote, hence, the argument put forward by the Intel that qualified effect test cannot serve as the basis of the Commission jurisdiction is incorrect. It is first time, dear learner, we have such a manifestation in an unmistakable term that the effect test or effect doctrine of the US antitrust law has no jurisdiction in European Commission happens to be incorrect. Let me reiterate once again the operative part of the judgment, which says, and I quote, hence the argument put forward by Intel that the qualified effect test cannot serve as the basis for the Commission's jurisdiction is incorrect, unquote. Thus, dear learner, what we infer out of this judgment that the European Court of Justice decision in the Intel case consistently applied the concept of conduct forming part of overall strategy in the jurisdictional context and cases of extraterritorial scope, putting different sets of conduct pursuing the same aim for the establishment of jurisdiction of the European Union competition provision seems reasonable. Thus, the European Court of Justice reasoning seems also appropriate from a consistency perspective and from the uniformity perspective, and the relevant conduct of an undertaking to be assessed in order for the competition jurisdiction in the context of Article 102 of TFU 2009. Taking and wrapping the entire doctrines of implementation doctrines, the polemical issues, the theoretical issues, and its vociferous manifestation under the Intel judgment, what we find that the implementation doctrine has certain broad generalizations. And one of the broad generalization happens to be that implementation doctrine represent an alternative legal construct as far as the extraterritorial application of European Commission competition law is concerned. Its advent reflecting the inherent limitations of the economic entity doctrine in that it could not be stretched to catch purely non-European player. Pursuant to this doctrine, what we find that it is based on territoriality principles, agreement and practices which fall within the purview of Article 81 and 82 of the Treaty of Rome, irrespective of the fact where they find their geographic origin. The decisive factor happens to be whether they are implemented within European community and trade between member states is affected. In this reference, dear learner, it is nothing but imperative to again look back the European Commission Court of Justice decision in wood pulp judgment or the case. According to wood pulp, it becomes relevant here because the judgment very clearly spelled out The criterion as to the implementation doctrine of an agreement is satisfied by mere cell within the community. Hence, no matter the location or the sources of supply and the production plant and where the anti-competitive agreement was entered into, thus on a corollary, we find that it is European community jurisdiction is triggered by simple fact that the products are directly sold to the community purchaser. One commentator on this case and this analogy and reasoning have commented that it has indeed argued that the triggering of the community jurisdiction on the basis of direct sales to the community purchaser sits uneasily within the public international law. And secondly, the other opinion which is being rendered on the outcome of the judgment happens to be that it does not constitute a sufficiently close and relevant link within the regulating state that is compelling enough to justify a jurisdiction on its part. Despite such misgiving, dear learner, the European Court of Justice and European Commission recently made explicit reference to the wood pulp judgment in order to assert jurisdiction over global price fixing cartel for licensing involving undertaking from the third countries, and thus leaving nothing to the chance and doubt. The theoretical discourse of the implementation doctrine, the polemical issues involved in the two leading judgments on the point, vis-a-vis the spiraling effect of the wood pulp case on the application of the implementation doctrine of extraterritorial application of competition law in European Union is something that needs to be understood in a very dispassionate and a very careful manner, and it settles and it fortified that in European jurisdiction, when it comes to competition law and when it comes to the extraterritorial application of the competition law, then we find that these two doctrines, the single economic entity doctrine and the implementation doctrine, are well settled propositions of the principles and policies of extraterritorial application of competition law. With this, dear learner, I hope that the study of these two doctrines will go a long way in deepening your understanding of extraterritorial application of competition law in the European Union. Have a happy learning, and in the next lecture, we will be discovering as to what extent the entire doctrines vis-a-vis the place of the effect doctrine is being well recognized under the European Court of Justice. Have a happy learning.